Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. I just prepared for bed. I had everything done. I wanted to step in, and all of a sudden I noticed, oh no. Oh no. Or oh yes, depending on how you view it. I missed an update from James Fillon about 1 hour ago. Two things which are definitely interesting came out. And I think I know exactly why. So let me tell you guys about it, all right? Attorney Lilia Tesler of Sidley Austin LLP filed an appearance as amicus curiae on behalf of the Chamber of Digital Commerce. Now, once more, if you're coming here for the perfect pronunciations, you might want to step up, get out of here, because it ain't gonna happen, right? I try my best. A little bit later, there's another joint filing. We'll talk about that in just a second. But this specific filing, Crypto Airy also shared a video for. Well, the filing itself, no, but the person which they are trying to basically get in here, yes. But let's quickly actually dive into the wording here because they're saying, amicus curiae. Okay, interesting. Well, guys, one thing we should understand by now is that the fact discovery ended because the deadline was August 31st, and so most likely there's not going to be any of these new motions to compel and whatnot because, well, getting the facts of the other party, that time frame is over. Right now, what they're going to be going into is the expert discovery, and the easiest wording for that is expert discovery is the period of time during which the parties exchange information about what the experts will say. This exchange usually occurs by deposing the experts. An expert discovery in complex cases can last several months. In this specific case here, it ends 13th or 12th of November. Once both stages of discovery are complete, the court will set a trial date. So that is still in the future, obviously, but right now, I believe we have November, I'm going to say, but let's actually quickly verify that just to be sure. I thought it was 12th. I might be wrong on that one, though. Let's quickly check it out here. November 12th, expert discovery deadline, and this amicus curiae, if that's how you pronounce it. Once more, guys, I am so sorry if I'm just butchering every single time. Friend of the court is what it is, in other words, and it basically is someone who is not a party to a case. So she's not on Ripple's side, she's not on the SEC side, she's just, helping the court, basically. She's somebody who exists. Oh, I have a beep in my ear. Sometimes, guys, do you have this too? I don't know if this is really random, but sometimes you're just walking around doing nothing, and all of a sudden you hear a big beep in your ear, and you think, yep, this is it, I'm going deaf now. Or just a little bit more deaf, at least I sometimes feel like, but whatever. Not really to any side of the party, to a case who assists the court by offering information, expertise, or insights that has a bearing on the issue in the case. The decision on whether to consider an amicus brief lies with the discretion of the court. The phrase amicus curiae is legal Latin, and in the United States, it typically refers to what in some other jurisdictions is known as an interventor or intervener, a person or organization who requests to provide legal submissions so as to offer a relevant alternative or additional perspective regarding the matters in dispute. In other jurisdictions, such as Canada, doesn't really matter, but in those areas, the amicus curiae is a lawyer who is asked by the court to provide legal submissions regarding issues that would otherwise not be aired properly, often because one or both of the parties is not represented by counsel. But that's not the case here. It's the first one. Because we actually saw it in the wording as well, right? That it is coming here from the Chamber of Digital Commerce. So she said, I'm in good standing of the bars of the states of New York and New Jersey, and there are no pending disciplinary proceedings against me in any state or federal court. Because I believe if that's the case, you cannot enter. I have never been convicted of a felony, nor have I ever been censored, suspended, disbarred, or denied admission or readmission by any court. Please find my declaration pursuant to Local Rule 1.3 attached here too. And so here's the whole list of it. Lilia Tesler declaring the penalty of everything, exactly what she's coming from here. Just basically everything said about her. I submit this declaration in support of my motion for admission to practice pro-hack vice in the above captioned matter to appear as counsel, because this is what she's coming here for, right? To appear as counsel and advocate for the Chamber of Digital Commerce. as shown in the certificates of good standing annexed here too. I am member in good standing of the bars. It doesn't all matter, right? She's not any felony, nothing like that. But she's basically coming here, I think, officially on the last day of fact discovery. But I don't think that really matters too much as well. She's basically just coming here to give some sort of expertise on something. And as of this far, so far into the letter, you can't really know exactly where or how or to what degree she's actually going to give any information out. It's just kind of a official lettering here, just written out really flat, like really, oh, I want to be seen. I know it's the official way to do these things, right? With official screenshots and all of this, or that's not a screenshot if it looks like this. You guys get the picture I'm trying to paint here. It's just all official stuff. It doesn't really say exactly what she's coming in for, but now because of the knowledge in the background, we know that she's here to give some expertise because that's the phase here. A couple of people asked why exactly this is going on right now, and to be honest with you, I haven't really found any really good explanations as to why, in the sense of what exact part she's coming here from, because, well, her being from, like we just said, the Chamber of Digital Commerce, you don't wonder exactly what sort of expertise she can give or what sort of new issues or new perspectives she will give and to what side. Will she be questioning the SEC? Will she be questioning Ripple? Well, interestingly, Crypto Area just posted, Attorney Lilia Tesler of Sydney Austin LLP filed an appearance as amicus curiae on behalf of the Chamber of Digital Commerce for the SEC Ripple case. Should she be advising Judge Netburn, which she most likely will, this is a valuable clip to understand her view of tokens crossing over as a security. Let me actually pick that up for you guys here. All right, I'm going to quickly open it up here. I have it open. There we go. Let me play it to you as well, if I can. It's about 1.5 minutes. Let me put the sound all the way hard so you guys can see it or listen to it properly. There we go.
I just wanted to discuss a little bit about this box in which these blockchains are trying to fit into now as a security from a legal perspective. The counter side of Brad's challenges, from an operational perspective, is that currently, if a token is viewed as a security on a blockchain, in order for it to comply with the securities laws, every time there's a movement of the token among two parties, peer-to-peer, that's a securities transaction. So the entity designing that blockchain, the issuer, or some other participants have to be registered as a broker or dealer, be responsible for trade reporting, comply with capital requirements, all of the securities laws that apply to a traditional financial services company.
Just sit at the back here. I want to quickly say, one important thing to kind of understand here is that she's referring to the infrastructure bill in this sense as well. Now, I'm not exactly sure where this clip is from. I'm not sure exactly when this was done, basically, this token summit. However, important fact, she is already kind of, in some easier words, criticizing the infrastructure bill with the narrative that she's putting it at. And in the infrastructure bill, there's basically a definition of broker. Right now, that's really broad. People are trying to get it a little bit more narrow, for example, because, well, if you have a network, you theoretically speaking, in the way that it's written right now, you basically always, any kind of participant in the network kind of is almost considered a broker, which is really odd. And following the SEC's rules, anybody transacting XRP right now is also sort of a broker, or at least a person who issued another investment contract. Then again, it's also not the case because it's kind of everybody having an investment contract with Ripple. Then again, every person sending it to somebody else is also kind of in violation. So then again, I'm not even sure how that one is supposed to work, right? Because the SEC's initial idea was that every single transfer of XRP is a securities transaction or violation, which means every single transaction is an investment contract. But if you're selling it to your brother, that means that you are selling a Ripple investment contract that you have right now to somebody else. That's still strange, still interesting to me. But I'm just hearing that in her voice.
And will vary based on federal, state, local requirements for each of those. And it's just not feasible to do so for blockchain companies. And that's part of the education and relief that we're seeking, that tokens that may be sold in a manner that complies with securities laws don't necessarily need to be securities when they're used on a blockchain.
And that's, again, a really key point. These tokens, which from the security laws may actually look to be securities to some degree, don't actually have to kind of act as securities. What I mean with that is she's also kind of broadening up the definition of security because it doesn't really work up anymore in this digital age. Because if you really strictly follow the laws, there could be quite a lot of cryptos which are securities, truthfully honest. Even Ethereum is one of them. If you really follow the law, Ethereum is a security, or at least has been. right? And then comes the question, should you always act upon that though? And does the security, way that we think of security, still matter and still work and still just sound logical? To me, it's just a question of why make such an overbroad definition of importance? Why make security such an important thing? Why not make securities for normal and digital securities, for example, where digital securities are just kind of have, for example, two parts, where you have the normal digital security, which can be any normal security but then digital, but also the cryptocurrency sense, which just where it doesn't line up. For anything that's kind of excluded, you have a different framework for it, because there's been so much back and forth, so much trouble. They could have gone through such an easy rulemaking process if they wanted to, yet they didn't want to.
Which is a little different than the regulation of digital asset exchanges, where the SEC has also been very active and trying to push for more registered entities in that space. People buying and trading securities on those markets may need to be regulated. So, trying to educate them on that distinction and where the current securities laws may be more appropriate from a regulatory perspective.
Once more, really beautiful speech on her end. I really, really liked her talk. And so she is right now coming into this case to give the court most likely some advice on some stuff, or bring up a couple of points of her own. We don't really know, right? Because once more, I'm not too good with all this stuff. And so as far as I have read it right now, once more, guys, in the United States, it typically refers to what in some other jurisdictions is known as an intervener, a person or organization. Right now, again, it's a person and organization of an organization who requests to provide legal submissions so as to offer relevant alternative or additional perspective regarding the matters in the dispute. Right now, the dispute, of course, is whether or not XP is a security, and whether or not they market it as one is also an issue that has come up right now because of the SEC's recent request. But basically, is XP a security, and have they undergone these security violations and whatnot? That's the issue at hand. And this Digital Chamber of Commerce individual is coming in to most likely spill her beans about the situation as an expert in the field. But then again, we don't know exactly, right? She could give her answer to 1,001 things. We don't really know. However, I do find it really, really peculiar, and I do like her perspective on it. It's not like a really conservative approach, which is like, no, crypto bad, regulated to the depths. No. She's good. I like it. Oh, I just pressed that away by accident. Can I recover it? I don't know how to recover it now. I'm dripping up a little bit. There we go. Okay, perfect. I accidentally got rid of it. However, let's see. There's another update on here that I almost forgot about just now by getting distracted. There was this one. Ripple and Chris Larsen filed a letter requesting permission to file a combined letter motion regarding an unidentified discovery dispute on which they have reached an impasse with the SEC. Brad is not part of the filing. So once more, guys, for me, it's already 1 September, but for them, it is still the 31st of August. And so they still have a couple of hours to put up a couple of, discussions, basically, I believe, right? Maybe, however, I'm just not affiliated enough with the law, and it could even be that they're going to post up newer issues a couple of days afterwards. I thought, however, that this was the deadline. Otherwise, what is the deadline there for if there's not a deadline? But apparently, we write on behalf of Ripple Labs and Chris Larsen, not Brad Garlinghouse, key, to seek the court's permission to submit a combined letter of 7 pages or fewer by both defendants regarding a discovery dispute on which we have reached an impasse with the SEC. We believe that a combined letter of 7 pages or fewer, which is below the 5-page per party limit provided by Section 2C of the court's individual practices in civil cases, best serves the interest of judicial economy and efficiency, given the overlapping nature of many defendants' arguments. The SEC consents to defendants' requests, and we consent to the SEC's filing a response that falls within the same requested page limit. So, what I'm guessing now is because this is Ripple and Chris Larsen, is that it has something to do with XRP's inception or everything that happened before Brad Garlinghouse joined in 2015, I believe, as the CEO. I believe, let's quickly see here. Brad Garlinghouse is not part of the filing. Jeremy also said, the only thing I can think of is that the issue must be only related to discovery from 2013-14. That would explain why Garlinghouse is not involved. Could definitely be so. Obviously, we don't know, but that assumption is definitely fine to make. One small part, however, could be that it is actually about an issue. Like, for example, guys, I read these things a lot, right? So you know by now. It could also be that it is regarding Ripple's sales of XRP or Chris Larsen's sales of XRP, because apparently Chris Larsen never provided at least as I know it by now, never provided an official trading record. He provided a lot of records, maybe not an official trading record, but Brad Garlinghouse did, and all other guys over at Ripple's team, I think in the company, also did before. But Chris Larson didn't provide everything. It could be that Chris Larson and Ripple's sales in that regard are actually what they're trying to hide here, and they can't come to a conclusion about that. But the fact that it's unidentified as of this point here does make me curious. Like, why did they not mention the issue at hand? I guess maybe they want to file it under seal as well, and that's why they're making it such a way. I also sometimes wonder exactly why it's being done this way. Then again, it doesn't really matter until we see it, I guess. It's going to be 7 pages, most likely not filed too long from now if the court, gives a thumbs up. And if you're wondering, guys, the court would just say yes or no to this request. One time before, she's actually said, no, I don't want to give you, the pages that you want. I'll give you fewer or more pages to do it, most likely than fewer, I guess. Or you have to file it separately. We don't really know exactly what they should do. Honestly, though, I don't really care if it's going to be 7 or 8 pages. I don't really know exactly why they would care either. But I guess we shall see. To be honest with you, I never really understood that part. But I guess it's just bureaucracy anyway, right? Because you have a limit of about 10 pages. It says here that you have a limit of 5 and 5 pages, basically 10 pages total. Why would you have to request to file less than that? Like, I don't get that part exactly. Then again, not a lawyer like that, so I'm not going to quote too much on it. However, generally speaking, if you're wondering about my opinion, I would say this is good stuff. Then again, guys, it's middle of the night. I wanted to go sleep, and I just, woke myself kind of back up to go talk about it. So if I'm dumb and saying some stupid stuff, you might as well just let me know in the comment section down below, and I'll hopefully rectify it tomorrow somewhere.